All right. Welcome, everyone. My name is Daniel Immervar. I'll be the moderator of today's discussion. And I should say that the discussion is co-sponsored by the Guam, Virgin Islands, Puerto Rico, New York State, and National Native American Bar Associations, along with the Right to Democracy, American Civil Liberties Union, and Latino Justice, Puerto Rican Legal Defense and Education Fund. I'll introduce myself. I'm a historian at Northwestern University. I wrote a book called How to Hide an Empire, A History of the Greater United States. And I'd like to just quickly set the table about the issue that we're talking about, a really important issue. When I think there's a kind of way in which a lot of people tell themselves lies about the United States, and it starts with the name. The name is the United States of America. It suggests that it's a union of states. But from the moment when the United States gained its independence from Great Britain and had that ratified to today, that's been an inaccurate name. It has not been a polity composed entirely of states, nor has it been a union, which suggests a sort of voluntary entry of those states as in a marriage. Rather, it's been an amalgam of states and territories. So we like to think, when we're kind of imagining the United States as a union of states, that this is a place of administrative homogeneity where all the states stand in equal footing with each other. But there has always been, every day of this country's existence, a part of the country that falls under US jurisdiction, but is subject to different laws or different administrative systems. And a really visible example of that is the capital of the country, Washington, DC. That part that falls outside of the Union of States is not just a footnote. It's often been quite a large part of the country. Historically, in the middle of the 20th century, the United States had the fifth largest colonial empire on the planet. And that briefly became the fourth largest after the defeat of the Japanese Empire. We think of empire often as a feature of the past, something that happened and is no longer with us, but that's not true. For one, the United States has some 750 overseas military bases, which are specks of half sovereignty all over the planet. It also has 5 inhabited overseas territories in which more than 3 million people live. And there are places that are technically no longer territories, but where the afterlives of empire still persist. When we are talking about the 5 overseas territories of the United States, I think it's important to recognize that they are subordinated by every branch of government. They do not send electors to the Electoral College, so in the sense people living in them cannot vote for president. And although territories have representatives at Congress, those representatives do not have effective votes, and federal laws often have carve-outs that apply differently to the territories than they do to the state. And then in the third branch of government, the Supreme Court, the Constitution, which the court is tasked with interpreting, does not fully apply in the territories. And often, by the way, this is surprising to people with law degrees. I've talked to people who've taken con law courses who are unaware of this fairly basic fact, which is that the Constitution does not fully extend and fully cover the entire country. And while that sort of exception to the Constitution is an artifact of a transparently racist past, it's also still a part of our legal landscape today. This matters, I want to submit, profoundly. It matters for the millions of people who lived in territories now. It also has mattered for the millions who have lived in them in the past. These are places where the US government has operated without guardrails. And it's not an accident that today all of the overseas territories are, in terms of per capita GDP, poorer than every state in the Union. It is also not an accident that some of the most violent events in US history have taken place in the territories rather than the states. The largest massacres, the largest police shootings, and the greatest civilian deaths from war. This matters too, not even just for inhabitants of territories. I want to submit that it matters for the entire country, including for the mainland. The book that I wrote, How to Hide an Empire, tried to argue how central the territories have been to US history. And partly that's because that once you sort of incorporate them into the story, you see that a lot of the stories that people tell about the United States aren't quite right. We tend to think of the country or talk about it as a contiguous republic. But in fact, it has always been a sprawling empire, not only with overseas territories and hundreds of military bases, but with all kinds of spaces that exist in a kind of legal twilight zone, the Guantanamo Bays of the United States. Such places, whether colonies, islands, or bases, have been sort of laboratories where certain things can be tried and done without the sort of oversight or the democratic responsibility that you would see in states. And so it's not an accident that, for example, chemotherapy and the birth control pill owe much to non-consensual studies done on Puerto Ricans. The territories have been where many wars start, from Bleeding Kansas, which led to the Civil War, to Pearl Harbor, which marked the United States' entry into World War II, to an attack on a military base that sort of led up to 9/11. And law has been really central throughout all of this, both to the legal subordination of all of the non-state spaces within the United States, but also to the exposure of this. Legal scholars and lawyers have really been in the forefront of naming and challenging empire, and that's why I am so looking forward to this discussion. We're going to have this discussion broken into two different panels. The first is going to explore how U.S. legal frameworks have influenced the identities, rights, and lives of residents of the U.S. territories. And the second is about what might be done about that, what kind of solutions are available to us. I will start each sort of get each panelist going with a question that the organizers have prepared. But please, there's a Q&A function available as part of this Zoom session. So please use that to formulate your own questions, and we will have some time at the end of each panel for those questions. So what I'd like to do to start this off is to ask the panelists on the first panel to, in order, briefly introduce themselves, and then we'll just get started with it. Thank you.
Sounds great. I think that's my cue, Daniel, and thank you very much. And thanks to the ABA for hosting this space and for bringing us here today. It's really a pleasure to be here with you all. My name is Adriel Cepeda Derieux. I am a Deputy Director of the ACLU's Voting Rights Project, where I work as a civil rights litigator. I was born in Puerto Rico, which I believe played a large role in my ending up doing the kind of democracy-facing work that I do today. As part of my work with the ACLU and with colleagues at the organization's racial justice program, we've engaged on anti-colonialism work related to the United States territories. And that's involved helping litigants by filing amici briefs to highlight the rights of residents of the territories, advocacy at the congressional level, and also working with colleagues like Latino Justice PROLDEF, which is represented here, to elevate the persistent problems that the people of the U.S. territories face. Since this spring, I've also had the pleasure and privilege to serve on the board of Right to Democracy, which is co-sponsoring the program today. It's an organization that directly tackles the framework that governs the U.S. territories through education, litigation, and connecting communities throughout the 5 territories. So it's an organization that's really at the forefront of the issues we'll be talking about today, and I didn't want to let a chance to go by without giving it a shout out, but thank you very much.
Thanks so much. Representative Plaskett, would you introduce yourself?
Hi, good afternoon. My name is Stacy Plaskett. I'm the representative to the Virgin Islands of the United States in the U.S. House of Representatives. I'm excited to be on this call and really grateful to the American Bar Association for taking up this issue and being really engaged in it. This is an issue that I have been working on before coming to Congress, and have tried to use this platform, this bully pulpit, to really try and discuss equity and the fair treatment of the peoples of the territories. I'm really excited about sharing with you the work that we've done over the years here in Congress and the work that's still to be done. So thank you.
Hi, my name is Ann Lopez. I'm the Attorney General for the state of Hawaii. I want to thank the ABA for inviting me to be a part of this today. The primary point I want to make about my job is that Hawaii is one of a handful of states that do not elect their Attorney General. I am appointed by the governor, and once confirmed, cannot be fired by the governor without 2/3 vote of the state Senate. And I think that this is important, that people understand that in my role, my job is to represent the state and all of my clients, which includes the legislature and the judiciary, I am the chief law enforcement officer of the state. And so my role in Hawaii is to be an unbiased law enforcement officer, whether it's civil or criminal. And in this kind of a context, when we're talking about civil rights and social justice, I want to emphasize that I am not running for a campaign. I am going to do my job, and I'm going to do it to the very best of my ability, but in an unbiased, apolitical manner. Thank you.
Hi, I'm Sherry Levin-Wallach. How are you all today? Welcome. I'm the Deputy Executive Director of the Legal Aid Society of Westchester County, New York, and the immediate past president of the New York State Bar Association. So I have so many people really to thank today for being here, and in particular, Mary Smith at the ABA for putting this webinar together and keeping these issues alive. I would be remiss if I did not give a special thank you to my friend and colleague, Representative Plaskett, who really inspired me to take on these issues and to focus on pushing the issues of the equal rights of the people of the U.S. territories forward and denouncement of the insular cases, among so many others that I know we're going to address today. So I will just end by saying that leading up to my presidency, we began educating lawyers and legal community on these issues, and I created the task force on the U.S. territories at the New York State Bar Association, and many of the speakers today are a member of that task force. So it's great to be with the family that we are, fighting for these rights together. And really, I want to shout out to all the people who are joined us. I noticed as we were signing on in the chat, we really have people listening from all around the US and the territories. It's an amazing showing of interest across the US. So thank you all for being here.
Justice Mernan.
Thank you. I'm Associate Justice Linda Mernan. I'm in the High Court of the Republic of the Marshall Islands, serving on a 2-year appointment here. I'm a U.S. citizen. I am currently an employee of the government of the Republic of the Marshall Islands. So I have to say this. Anything I say today is in my personal capacity and not on behalf of the government of the Republic of Marshall Islands or the government of the United States. I'm a retired U.S. Air Force colonel. Served 30 years on active duty, including 10 years as a military judge and chief circuit military judge. I did the first combat deployed trials in Iraqi and Enduring Freedom, and also worked 8 years with the United Nations doing war crimes cases. It's my honor to be on this panel today to speak about my experiences here in the Republic of the Marshall Islands. Thank you.
Wonderful. Adriel, could you start us off by explaining the legal framework surrounding U.S. territories and the impact that that has on the voting rights and civil liberties of people who live in them?
Sure. I'll give it a shot, and thank you. I think you set the table quite nicely at the beginning, Daniel. And I'll start by being precise. When we speak about the U.S. territories, we currently speak of 5 specific islands, and if we're being even more precise, some are islands, some are archipelagos, but we're generally speaking about America and Samoa, the Commonwealth of the Northern Mariana Islands, Guam, Puerto Rico, and the U.S. Virgin Islands. And I would say I call those the current U.S. territories, and as you said, it's important to sort of frame it in that sense because the United States has always had territories from day one. At the start of course, as we all know, is 13 states in the eastern seaboard, but also this huge swath of land to the west that ends up being Ohio, Indiana, Illinois. And the country adds more territories as it grows to the point where in 100 years it's stretched from one side to the other in the Pacific coast. But for most of that period, for the entirety of that period, really, it was understood that as the United States added these new territories, those territories would eventually become states, and the people in them would eventually become citizens. And that all changes between 1898 and 1901, when the United States beats Spain in the Spanish-American War and suddenly finds itself in Puerto Rico, Guam, and the Philippines. The United States finds itself now with territories that were frankly and bluntly quite different. They were islands across the sea but maybe most importantly, they were inhabited by people that weren't going anywhere. They couldn't be forcibly moved, for example, as the indigenous people who had been in the continental territories had been. But also they were different culturally. They were mostly Hispanic, or they were Black, Pacific Islanders, Asian. They were, predominantly Catholic from hundreds of years of Spanish influence. Most didn't speak English. And that prompts or spurs some self-reflection in the United States, and particularly among let's call it the political class. Because if the United States was historically or constitutionally bound to absorb these people, then could it do imperialism on how the European powers at the time were doing it by just essentially colonizing? The United States was not a monarchy. It was founded on democratic principles, if one sets aside the glaring blind spot of slavery. And so what do you do with all these people? And so starting in 1901, the United States Supreme Court starts answering some of these questions by saying the United States gets to thread the needle. It gets a bit of a pass. It didn't have to absorb these people into the national fabric, at least not entirely. And that happens in a set of cases that come to be known as the Insular Cases. And what the Supreme Court says is that there are essentially now two types of territories, those that are incorporated and those that are unincorporated. And really the only difference that the Supreme Court says is whether Congress has said that whether Congress has said that the territory is en route to become a state. If it has said that, then it's an incorporated territory. If it's not made that clear, then it remains unincorporated. Now, those unincorporated territories, they end up being the ones that I spoke about earlier. It's still Puerto Rico, Guam, American Samoa, the Commonwealth of the Northern Mariana Islands, and the U.S. Virgin Islands. So long as Congress doesn't say something is on track to become a state, it's now understood that those territories will remain on some kind of limbo. It could become a state eventually. It could, presumably, but it could also presumably back out, as many scholars have written about. It could become independent. And you see the Philippines, for example, eventually have that result. But in the meantime, it just be part of the United States in some sense, to borrow language from the decisions. It would be foreign in a domestic sense, which is, a phrase that gets used around, and it's still confusing to me, as it was to many at the time. But I think, the important thing to keep in mind as a framing matter is, and to always come back to, is that the Supreme Court didn't hide why that distinction was needed. It was very clear that it was needed because the people there were different. The Insular Cases are explicitly racist. There's no hiding it. The new territories were different. The court said, these are the court's words, because the people who lived there were, quote, uncivilized. They were unfit to be part of the nation. There's references to savages, to how they were restless. It speaks in terms of the people who live there not being Anglos. So any discussion about the persistent issue of the United States having territories of this enduring colonies problem, it really has to part from that undisputed understanding that the origin of the story has white supremacy at the root. You asked me what that means as far as civil liberties. Again, you have to start at the Insular Cases, and those have essentially been taken for the notion that the Constitution applies, quote, in full in incorporated territories, but only in part in unincorporated territories. Now, I'm of the school of thought that distinction has been overblown. I feel like the Supreme Court has never been that starkly clear about it. In fact, it's sort of been walking it back for decades, but it's never overruled, that distinction. So it just keeps coming up and coming up. So in practice, every time you have a case involving, or a matter or an issue involving the civil liberties or civil rights of the residents of the territories, you can almost be sure, you can almost bet great money that someone's going to argue that the right at issue maybe just matters differently there, or should be taken differently there. Searches and seizures, policing, abortion, same-sex marriage, you name it. It all gets refracted through this first step of whether or not the right actually even applies in the territory. You mentioned voting rights, so I'll speak to those specifically. There's very little question about whether territories can have voting representation at the national level. And I say voting because we're obviously joined by Congresswoman Plaskett, who represents her constituency so admirably. But the Constitution speaks of states having voting representation in Congress, of states having senators, and of the residents of the states being able to vote for president. So there's little question that so long as territories remain territories, they'd be unable to send voting representation to Washington, D.C. And I think that's kind of where we can leave it. You know, I'd say that I'd point out that it's important to ground it in terms of that, whether or not they remain within the U.S. framework, because obviously there's serious debates in the territories, as I'm sure many of the folks who are joining us and are interested here, about whether the people of those territories prefer to join the union eventually as states, whether they prefer to be independent or have some sort of arrangement in the middle. But within the constitutional framework of United States law, anyway, that's the framework. And I guess the last thing I would say is, you know, not just voting rights, but taking a step back, this idea of whether it's in full or in part and on incorporation, it really keeps all rights, including the rights of voters of in the territories, the rights they have to elect their own representative in the shadows. So, for example, courts have determined that the idea of one person, one vote, which is the bedrock of representational democracy in the United States at this point, doesn't apply in the Northern Mariana Islands. It does, however, apply in Puerto Rico for reasons that the courts haven't wrestled with and haven't really given a principled explanation for. Do the people who reside in the territories have a constitutionally protected right to vote? I would say absolutely. In fact, I've litigated cases on that premise, but the question still comes up far too frequently at the top of the case. And it you know, again, it goes from the right to be free to searches and seizures. Shouldn't be different whether you're in Pennsylvania or if you're in the U.S. Virgin Islands, but it's been litigated. Your right to reproductive freedom shouldn't be different whether you're in New York or Guam, but that's been a source of litigation. And that's where we are. And that's where we've been going on 125 years, which is at this point longer than the time from the founding to the Spanish-American War. So this is a situation that has persisted now for the bulk of the nation's history.
Thank you so much. That was really helpful. Representative Plaskett, I'm wondering if you could just say what this looks like from the perspective of your constituents in the U.S. Virgin Islands, how this legal framework affects their rights and indeed their lives.
Sure. I think, you know, we can talk about how it affects individuals on a regular basis in their daily life, as you can imagine, not having the ability to vote. I think in particular, we just finished having Veterans Day and thinking about individuals who have served in the territories, most of them in greater number, in most territories in greater number than they do in the United States. But they are supporting a commander-in-chief that if they were residents of the Virgin Islands when they came into the armed forces, they did not vote for. And then when they go back home as veterans, because of they are living in a territory, there are some benefits to which they are not given. They are often excluded. Oftentimes it's just forgotten that they should be included in a particular benefit that is for everyone else that have served our country. And so that's just one very glaring area in which one can see the differences. Of course, it comes to an area that we just finished a fight on was Medicaid. before the 2017 hurricanes, Congress just did, well, let me back up. In all states, the federal government pays a portion of Medicaid. And that percentage that the federal government will pay is based on the demographics of a particular state. So a place like New York, the federal government will pay 55% of a Medicaid cost for an individual, and the state pays the rest. In a place like Mississippi, the federal government pays approximately 80% of the cost of Medicaid, and the state pays the rest. Well, throughout the US territories, Congress, which has the sole oversight over the territories, just came up with a percentage that was not based in any kind of reality in terms of the demographics, which was we, the federal government, will pay 55%, and you, the territories, will pay 45%. That meant in practice that territories like the US Virgin Islands decided that we're going to make the threshold by which someone can qualify for Medicaid much lower, because we have a finite amount of money to be able to enroll people in Medicaid. A place like Puerto Rico decided that, whoa, we've got so many people that need this. We are going to utilize funds that we may not necessarily have to meet the demand of what that person's income is. In essence, and quite often what Puerto Rico did was issuing bonds and using monies that were tied to the Puerto Rico government, the good faith and credit of Puerto Rico, to be able to supplement things that the federal government did. And this is in many ways a reason why Puerto Rico ended up in bankruptcy. So the Virgin Islands just said, you know what? You're just not going to get health care. Puerto Rico said, you know what? We've got to provide us, and we're going to go bankrupt doing it. Both have travesties, and both have long-term ramifications. Last year, we were able, however, to get Congress to say, you know what? That's not based in any reality. And there are unseen costs that actually are imbued and given to the United States, the federal government, by in fact not doing that. And so now moving forward in legislation last year, Congress changed that so that we are in fact receiving money by demographics. So in practicality, a place like the Virgin Islands, which has a population of approximately 100,000, we were able to add, when Congress changed that rule, near almost 20,000 people onto Medicaid. That's how many people in the Virgin Islands live in poverty, and that's how many people were not receiving Medicaid. So these are, Daniel, the practicable ways in which not having equity and not being treated fairly plays out. And just think about that. So you don't have these people on Medicaid, they have no health insurance. The outcomes are that they go to the hospital when they have an emergency, they do not pay, the hospital is then in the black, the hospital's not to be able to make improvements to its roof, to its others. You have a hurricane in 2017, and what happens? The hospital is destroyed. So these inequities really affect people in everyday lives. And what I have been trying to do here in Congress is, one, first being present and not being relegated to a position of acting as though I am, in fact, a second-class citizen. I can recall when I first came to Congress, all of the members of the territories, up until I arrived, all members of Congress get 2 committee assignments usually. Unless you're on an exclusive committee, you're assigned to 2 committees. So all of the members of the territories sit on natural resources. When I came to Congress, which has the Insular subcommittee, when I came to Congress and the leader of the Democrats said, oh, okay, you're going to sit on natural resources, and what other committee do you want? And I'm like, I'm not going to sit on natural resources. And she was like, what are you talking about? Everybody sits on natural resources that comes from a territory. I'm like, yeah, but we've got 3 other people from the territory sitting there. We're not in the other committees because we only can be on 2 committees that we could be on to be able to spread our influence and our voices. And so I'll just check in with them and I'll give them the issues that are important to me. But just like New York, all members from New York do not sit on financial services, although New York is the financial capital of the world. Why would all of us sit on natural resources? That's effectively an apartheid committee in some ways for us to be that, to be relegated to that. And I think that then kind of broke the mold, and you've seen other members doing things differently. We had a member from Guam who was sitting on the Financial Services Committee, which had not happened before. I, in the last Congress, sat on the Ways and Means Committee. There had been an agreement, if you can believe this, an unofficial agreement between Republicans and Democrats when territories first started coming to Congress in larger numbers in the 1970s, 80s, that they said, we will never put a member of the territories on Ways and Means Committee. It is too important a committee. It is an exclusive committee and it is making decisions about tax and revenues, and it cannot be wasted on someone from a territory. So being someone who's from a territory sitting on there is the reason that they changed the Medicaid formula for us. It's the reason that we're able to do these things by being present. When you talked about voting on the floor, members of the territories do not vote on final passage. We only vote when we are in committee of the whole. So you're voting completely when you're in committee, but you're only voting on the floor when there's votes in committee of the whole, which are amendments. So there are some days or some portions of the day when there are no votes in committee of the whole. Many of the members of the territories do not come on the floor during that time. I go on the floor because if I want the rights, the full rights, I have to take the responsibilities. It's the same way that my grandfather's generation, when we became part of the United States, they lobbied Congress and said, we want to be part of the draft. Because with the responsibility of being, the privileges of being Americans, we want the responsibilities. And that's what members of the territories are saying. That's what the people of the territory are saying. So doing that and being engaged has, I think, allowed us to have some benefits. Looking at the changes in law related to the Stafford Act after storms for the territories. Even in the last 2 Congresses, in the 116th and the 117th, the primary legislation, H.R. 1, in Congress, the H.R. 1 is whatever the majority thinks is the most important piece of legislation, was the For the People Act. And it involved issues of voting rights, et cetera, that the majority felt was important. We were able, the members of the territory, to put a section in there on the territories, creating a commission that must come up with what has been first the impact of not having full voting rights, economic, social, political, for individuals living in the territories, and what is the path for them to have those voting rights. That's been important. Continually bringing cases before the Supreme Court, and us as members of Congress, as governors, as former governors, signing on to amicus briefs. Because I'm always reminded, Brown versus Board of Education stopped desegregation in school. But Brown versus Board of Education was not the first case that made its way up to the Supreme Court. And so we've got to continually bring these cases forward. We've got to continually knock on the door. We've got to continually be heard. I'm frustrated by both the Democratic Party and the Republican Party in their platforms at conventions saying that people living in the territories should have the right to vote for president. But when these cases come before the Supreme Court, they side in favor of the insular cases. I'm discussing with others, how do we bring political pressure to bear on whoever's sitting at 1600 Pennsylvania Avenue to ensure that they live out the mandate of what that means. I'm grateful that in prior cases that were before the Supreme Court. You know, you look at the amicus briefs that were signed regarding Fifi Tua versus the United States. And I'm sorry, I'm probably butchering the name of the individual there. But who was the author of the amicus briefs for the former elected officials was Paul Clement, or former Solicitor General. And who argued the case on behalf was Ted Olson, another Solicitor General. So we've got to continually have these discussions. I'm grateful for the American Bar Association bringing this to the forefront and having this conversation, because it's only until we continue pressing this and letting the United States infrastructure know that you still have an empire and you still have subjects that are living under an empireship that we're able to break that. So thanks.
Thank you so much. Attorney General Lopez, Hawaii has gone on a journey from territory to state, and it's been a complicated one, especially for the issue of the rights of Native Hawaiians. I'm wondering if you could speak to how you think of that broader narrative of territorial evolution and legal identity and what it means for U.S. territories.
I'm not actually going to go into that broader spectrum that you've just described, in part because that's not my area of expertise, and I don't want to suggest otherwise. What I do want to do, though, is provide people with sort of what that time frame, what that timeline and evolution look like, and weave into this timeline the important events that touch the lives of Native Hawaiians and the Indigenous people here, and sort of how that really has not progressed very far. And so not incredibly sexy, but I hope that it gives people a little bit of an understanding of how Hawaii got to where it is today. I think many people know that prior to 1778, the Polynesians who voyaged to Hawaii lived without contact from America, Europe, or really any other nation. Once Captain Cook arrived in 1778, he was followed quickly thereafter by American missionaries. King Kamehameha III at that, the king at that time, and then King Kamehameha III had absolute power in his monarchy. But in 1839 and 1840, the king issued what are called the Rules and Laws of Hawaii. And in 1840, he signed that as the first constitution of the Hawaiian Islands. And in that, he relinquished some of his absolute power and created a legislature and a judiciary, and allowed the chiefs and people to be able to vote for members of the legislature. Then I think a very important point in both Native Hawaiian rights and the development of Hawaii is what is known as the Great Mahele. Up until 1845, the king owned all of the lands in the Hawaiian Islands. He created a land commission in 1845 that would have the effect of dividing those lands into three categories and would give rise to private ownership of land in Hawaii. The Great Mahele divided the lands into three, roughly 1/3 each in terms of the land value, into the crown lands, which remained in the ownership of the king, the lands that were given to his chiefs, and the lands that went to the government. And this becomes important because after the 1893 overthrow of the monarchy, then Queen Liliuokalani was the queen. At that time, the Republic of Hawaii was created, and those crown and government lands were ceded to, or not, were basically, I'm going to say stolen, but were taken from the queen and moved into the Republic of Hawaii. And then in 1898, is when Hawaii became a territory in the United States. And through the annexation of Hawaii, those lands were officially ceded from Hawaii to the United States. At that time, in the annexation, the United States Congress determined that the Crown and government lands and all the proceeds from those should continue to be used solely for the purposes of the inhabitants of the Hawaiian Islands for educational and other public purposes. And then in 1900, we had the Organic Act, which was basically provided three important points, one of which you've all talked about today. But the first is that all of the inhabitants of the Republic of Hawaii became citizens of the United States and citizens of the territory. The US Constitution was said to have the same force and effect in the territory as it did in the United States. But while the territory had the right to have a delegate in Congress for purposes of debate, it did not have a right to vote in that capacity. In 1920, Prince Kuhio, who was the delegate to Congress, urged Congress, and they did, to pass what's known as the Hawaiian Homes Commission Act. And the purpose of the Hawaiian Homes Commission Act was to support the self-determination and self-sufficiency of the Native Hawaiians who had been displaced when the monarchy had been overthrown. Native Hawaiians, in the context of the Hawaiian Homes Commission Act, are defined as people who are descendants of Polynesians, but with a blood quantum of no less than 50%. Now imagine this many years after the overthrow, how many people would continue to have a blood quantum of 50%. But the Hawaiian Homelands continues today. It continues to have that 50% blood quantum, but the lands are supposed to be used for farming and homes of Native Hawaiians. Congress had determined that Hawaii had qualified to become a state in the 30s, but after the bombing of Pearl Harbor, all of that was put on hold. So coming back again in 1959, it was determined that Hawaii qualified to become a state, and the Admissions Act was passed. And the Admissions Act is important because those Crown and government lands that were ceded to the United States were returned to the state. And again, the proceeds in the Admissions Act of those lands were to be used to benefit Native Hawaiians and the people of Hawaii, particularly in areas of education and public purpose. Not a lot happened with the Hawaiian homelands for a very long time. And today, recently, I'm going to say about a month ago, after 25 plus years of litigation, the state settled claims of Native Hawaiians who had been on a waiting list for their entire lives, some who died while they were on the list, because homesteads had not been issued to them. They did not get the land that was promised in the Hawaiian Homes Commission Act. We just settled that case, and the legislature appropriated $328 million to settle those claims, and appropriated $600 million to Hawaiian homelands to really change what's happening and begin to create neighborhoods and places where people could live and build their homes or farm. Because Hawaiian Homes requires a 50% blood quantum, there's a huge, larger swath of Native Hawaiians who don't benefit from that at all. In 1978, Hawaii amended its constitution to create the Office of Hawaiian Affairs. The Office of Hawaiian Affairs, through that amendment, requires that those Crown and government lands the proceeds from those, portions of which have to go to the Office of Hawaiian Affairs. And what that means, for example, is that our airport is on ceded lands. And so 20% of the revenues from the airport go to the Office of Hawaiian Affairs. And the Office of Hawaiian Affairs uses those money to improve education, public health, and the ability of Native Hawaiians to be self-sufficient and self-determine their lives. So I kind of wanted to go through that because you see two parallel timelines occurring, not just what's happening with the state, but the efforts of what's happened to the indigenous population in Hawaii, from lands being taken to them to some being returned, but not really getting anything out of that return. And so this issue of Native Hawaiian rights and self-determination continues to be at the forefront of everything that happens in Hawaii, from the building of the 30-meter telescope on the Big Island, which University of Hawaii had just sort of planned to move through, until Native Hawaiians stood up and argued that this is their land. These are their ceded lands, and these are the lands of their descendants. And so that project was put on hold. And so becoming a state didn't solve any of necessarily the problems that the Native population experienced from the day Captain Cook arrived, and that struggle continues today. We don't necessarily have answers, but we're still struggling and trying to find the right path.
Thank you so much. Fantastic. Justice Murnan, you have extensive legal experience, and I'm wondering how that makes you contextualize or understand the legal identity and rights of residents of territories like the Republic of the Marshall Islands.
Thank you so much, and I'm honored to be on this panel today with all of the other esteemed guests. I have to say that I knew less about the Marshall Islands than I probably should have when I came here. And my goal now is to make sure everyone else that I know across the United States knows as much as I do, having lived here and observed the impact of colonialization and the condition in which the United States left this independent nation when we became an independent nation in 1979. The Marshall Islands, unlike some of the other territories that you'll hear about in today's discussion, did become independent in 1979. But that was not without paying a dear price for having been a colony, or having been under the, quote, administration, end quote, as a trust territory. So for everybody who uses the word trust, and you hear about an administrator of a trust, you have a sense that you're supposed to act what? With a fiduciary responsibility to the people for whom you are the trustee, right? And so again, I gave my disclaimer at this front end, so everybody should know I'm still a US citizen. I plan to come back to the United States, but this experience living in the Marshall Islands has been so eye-opening and so disappointing, especially in my perspective as a 30-year service veteran, military service veteran. For many who don't know, when the United States invaded the Marshall Islands in World War II, it replaced multiple other colonizers. It has a long history, just as Attorney General Lopez talked about with Hawaii. Germany was once here, Japan was once here, Spain was once here. I mean, they've all been here too. But the United States became responsible under the United Nations Trust Territory Agreement to be the trustee for the Marshall Islands. And during the period of time when they held it as a trust or served as the trustee, between the period of 1946 and 1958, the United States decided it would be an appropriate thing to do to conduct nuclear tests in the Bikini and Eniwetok atolls. And I have to say that's I go back to the original opening comments of our first speaker who said you can't displace the people, they're indigenous. Well, they did displace the people here. They removed the people from the Bikini Islands. They removed the people from their homes in Eniwetok. And what they promised them is that they would get to go home. But they haven't been able to go home because the long-term devastation of the nuclear testing that occurred in Eniwetok and Bikini Island still permeates everything that we do here in the Marshall Islands. And those people are still displaced from their original homes. And I don't see that they will likely ever be able to be returned to their island or to their atoll or to their original native home. Another thing I wanted to comment on was the very welcome comments of Representative Plaskett. I am a veteran, and proportionally the number of U.S. military veterans in the Marshall Islands far exceeds any percentage of individuals who have served in the U.S. military in any state across the United States, percentage-wise. Now, we're a small country, we're a small nation, but the percentage of people who have served their country in the U.S. military, served what is not their country as members of the U.S. military and are entitled otherwise to veterans benefits is astonishing here. And let me tell you what a U.S. veteran is able to achieve here. Nothing. There are no VA services in the Republic of the Marshall Islands. When I got here, I'm a VA accredited rep. I represent folks and assist them in getting their benefits before the VA. And I was shocked to learn that there was no one here, no one in the Marshall Islands to assist them in applying for benefits. Now, they did have a visiting team come in from the Philippines after I got here and after I started raising noise about this. And I don't know that I had anything to do with that, but I will say there was no one. And I asked at the U.S. Embassy that's here on the grounds, I said, what are you doing for U.S. Embassy? What are you doing for U.S. military members? They said, well, we don't have that large a staff. And I said, well, here's what I'm going to do. And I started assisting veterans here and applying for their VA benefits. My first 2 veterans that I assisted started in January of 2023. They are still waiting for an adjudication on their benefits claim. And why is that? Because there are no medical assessment teams here to do VA medical assessments, none. And so from January to November, these are both PACT Act qualified veterans, veterans who served in Vietnam, veterans who served in Korea, veterans who are qualified for benefits. And in 11 months, we haven't been able to get an adjudication because there are no medical services for the veterans here provided by the VA. So what do I, as a global overview, having worked all over the world in my role in the military and in my role with the United Nations, what do I see here? First of all, I would urge people to very seriously review their Western-only perspective about people. I had the honor a week ago today to attend the coronation of one of the principal chiefs of the Republic of the Marshall Islands. They have a parliament and an elected president. And they also have, by their custom and tradition, a royalty class. And I attended the coronation of one of the principal chiefs, Christopher Loyack, last week. I don't think people in the United States understand the degree to which we disrespect the custom and tradition of individuals whose customs and traditions we displaced through our colonization. And when we finally allow them to return to their roots, when we finally allow them to be restored to the people that they once were, the lack of respect for those specific custom and traditional rights is so critical and needs to be understood. And it needs to be understood in the United States of America, and it needs to be understood, frankly, in the American Bar Association, among other places. So I would just share that. And I am not the only person the Marshall Islands are not the only place where this is true. It's true in all of the indigenous countries. I see that my time is probably very limited, so I'm going to conclude there, and I'm happy to answer questions. Thank you.
Thanks. That was terrific. Sherry, could you speak to what individuals and organizations on the mainland can do to effectively support civil rights, social justice for residents in the territories?
Absolutely. And thank you. And it's really a pleasure to be here with all of you. This is amazing panel and discussion. So I think the first thing, and the question is right there. Why am I involved in this? People ask, why is this something that I'm so passionate about? Why does it matter? Well, I mean, I'll give just a quick answer personally as a criminal defense attorney and somebody who's fought for equal rights my entire career. These issues are steeped in significant problems that are endemic of our society. And in particular, when we look at the issues of racism and the civil rights movement, the idea that we've made it through a civil rights movement, and yet we still have cases on our books as good law that can refer to individuals by reference, by just referencing a case as different, as barbaric, as unable to live by Anglo-Saxon norms. And I'm quoting the Insular Cases here in some way, partially. These things are just not acceptable. But more importantly, this does impact the people on the mainland, and they don't recognize it. So most people, I would say, I shouldn't say most, but many people on the mainland either have enjoyed spending time in one of the U.S. territories or aspire to go to one of the U.S. territories. And many think about retiring to a U.S. territory. And I think the majority of people, unfortunately, don't know, and I'm making that conclusion just based on my own conversations with individuals, is that you, as somebody living in the mainland, born and raised in the mainland, somebody not of descent from one of the U.S. territories, still would lose all those rights, still would have unequal protection under the Constitution. And we have to start there. Because if our Constitution doesn't equally protect every person that is considered a U.S. citizen or national, and I call out American Samoa because many don't recognize that the status is different. I think it's important to recognize, but nonetheless, that there's not equal protection, then we start there. And so, from a legal standpoint and from the standpoint of organizations, bar associations, and educators, because that's what we are as well, it is important to start with that, to educate the communities, in particular the legal communities, but even beyond the legal communities, all of our communities, on these issues that are U.S. issues. They are part of the issues that face us as a people. And we cannot and should not ever look at a group of individuals within our society and say, oh, that just matters to them. And because that is the basis of a lot of the discrimination and segregation that we've had in our history and that still exists here today. So I think moving forward now beyond that to talking about what can we do? I think education is highly important, is one of the things that we can do. And I'm going to start there. When I became engaged and involved with these issues and made aware of the issues, I was shocked, as most lawyers are. And I every day encounter somebody who doesn't understand or has never heard of the Insular Cases and never heard of these distinctions, which shocks me, but it also shocks them. I've engaged with members of the judiciary who say, how is it possible that I don't even know these cases exist? And so education of the legal communities is paramount. And that's one of the things that the American Bar Association, the New York State Bar Association, and many other bar associations now are doing. I've been working very closely with a number of bar associations, in addition to all the bar associations and representatives from the U.S. territories. But also the bar associations in the mainland, the New York City Bar Association, New York State Bar Association, the American Bar Association, California Lawyers Bar Association, and I can continue to go on. But I think it's really important to get the discussion out there. We present CLE programming. I'm beyond counting how many we've done. We've done programming through the New York State Bar Association. We've done programming through other bar associations, the ABA, but also at the law schools. We've done programming at Columbia Law School, at Fordham Law School, at New York New York University Law School, in conjunction with these law schools, we've done programming. This is really important to do because it's raising the awareness of the generations that are now being educated. And so that's one thing. The other is to pass resolutions to prepare our associations and organizations to be in a position to fight against the historic acceptance of not only this case law and these rules of law, but to denounce the insular cases and support the efforts to overrule those insular cases. And that's twofold. One is done through working on cases, through amici, with organizations such as Right to Democracy, Adriel mentioned. I work very closely and have worked very closely with Right to Democracy. Neil Ware and Adi Martinez, they're co-directors. In fact, I just did a panel in Puerto Rico with Adi on this issue last week. And so this is one of the things we do. We join together and prepare ourselves. The members of Right to Democracy, the Right to Democracy team, they join in these amici, they bring the cases and we join in the amici. So there are many ways to do it, but also legislatively. And this is actually a conversation that we've had in many of our discussions. Right to Democracy held a symposium in New York City with representatives of all 5 territories that I attended 3 weeks ago. And at that symposium, we talked about these very issues. What can we do? Is legislation the way? Is creating, trying to influence case law the way, or overruling of the insular cases? We agree, it's both. And so to Representative Plaskett's points and others, bringing resolutions before Congress, bringing it to our legislatures and asking them to look at these issues is incredibly important, because ultimately it is the congressional, the legislative push that can influence, and it is Congress that created the unequal status, the unincorporated territories to begin with. So we've passed resolutions at the New York State Bar Association to support these efforts. The American Bar Association has passed resolutions to do so. In addition to supporting the efforts in the case law, the American Bar Association, among others, and I don't have time to go through all of them, but the most recent have been the one to position us to file amici in the Fitzsimonu case, which unfortunately was denied certiorari. But both the American Bar Association and New York Bar Association are ready, willing, and able to do so based on the resolutions that we passed. But also the American Bar Association passed a resolution to encourage the teaching in constitutional law cases of the insular cases as part of the curriculum. And I think very slowly now this is starting to erupt and become more commonplace discussion within the law schools. Our programming is not limited to lawyers. It's open to communities. We've done community outreach programs in the territories and in New York, and with the ABA as well. So I think these are some of the ways. I know, and I saw that Bruce gave me the high sign that we have to transition to the next panel. So I will end by saying this. I just touched the surface. We all just touched the surface here today. There's so much to be done, but I will say that we are a group amongst the US and the territories that work together all the time. And I love it when we see new individuals and bring in new people who are interested and engaged. So we are continuing to do that. And it's now part of my mission as a lawyer and as a person. And, I think it's wonderful that we're all here together to make this significant change that needs to happen.
Sure. Thank you so much. And that's a wonderful transition to the next panel. So if I could ask the panelists on the second panel to put their cameras on, and the panelists on the first panel, you might go dark and join the audience. Same format as before. We'd like to have the panelists first briefly introduce themselves, and then we'll go into questions. And we're running just slightly behind time, so we'll try to keep it quick. So starting with Jacqueline Terlahi, and then we'll just go from there.
Half a day, Jacqueline Taitano Terlahi here. I'm an Indigenous woman from Guam, from the people called Chamorro, also related to our Northern Mariana Islands. I'm a solo practitioner in Guam, and I'm also the president of the Guam Bar Association. In terms of the work that I focused on in the territorial area, I work with Sherry, with Neil, Right to Democracy, Addie, with many of you who are on this panel. But my focus has really in the last few years been on the education side of attorneys. I started going to the American Bar Association about 6 years ago and realized that the leaders of our country, which many of them are lawyers, right, in this ABA delegation, have no idea about territorial law, which started the relationship with the New York State Bar Association, the California Law Association, and the different territories. So we have started to get together to work on all these issues together and to do educational programming across the world. Yesterday, I was at the University of Guam talking to students about these issues. So education has been something I'm very interested in, and I will stop there so that we can introduce ourselves.
Thank you. I believe I'm next. I'm not sure because I'm not looking at the run of show, but here I go. My name is Leah Fiol-Mata. I'm a senior counsel at Latino Justice, which is a national civil rights organization that has been working for over 50 years, defending and promoting the rights of the Latino and Latina community, both in the United States as well as in Puerto Rico. I am Puerto Rican. I grew up and did all of my schooling in Puerto Rico, except for law school. I'm a proud graduate of City University of New York School of Law. And at Latino Justice, I dedicate my time primarily to two areas. One of them is economic justice issues, particularly workers' rights. With my background as a union side labor lawyer and plaintiff side employment lawyer, as well as I co-lead the Puerto Rico pillar with Roberto Cruz, who's at our Orlando office. And we focus on many things related directly to Puerto Rico. We focus our attention on government transparency, on fighting against discrimination against Puerto Ricans, both in the United States as well as in Puerto Rico, on combating the energy crisis and all of the conditions that contribute to the displacement and the migration of the residents of Puerto Rico to the United States. So I'm very happy to be here, and I look forward to our continued discussion.
Carlisle. Dr. Corbin.
Yes, good morning. From my vantage point, good afternoon from where you are. My name is Carlisle Corbin. I am an international advisor on governance, and I was involved presently with the Dependency Studies Project as a senior analyst, and which was an expert group founded about maybe 15 years ago or so. We have developed a self-governance diagnostic tool, which measures the level of self-governance in non-independent territories globally. So we include the U.S. territories in that mix. I used to be the external affairs representative of the U.S. Virgin Islands, where I served 5 governors over the period. And also during that time, in the context of that, representative to various United Nations organizations, including the United Nations Decolonization Committee, as well as other UN bodies. Have been involved with the territorial issues for some time from the perspective of US territories. As far back as the 1990s, we had a group known as Offshore Governors Forum of the 5 US territorial governors, which is more of a collaboration group, lobbying group. We also developed links with our neighbors, particularly the British Virgin Islands, which is our closest neighbor. And very recently, I was involved in conjunction with the University of Guam and the Commission on Decolonization of Guam, the development of a Jihad Mona self-governance study for Guam. And this was something that is now used for the purpose of the political education program in Guam, leading to a referendum at a future point. My work with the United Nations includes being Executive Secretary of the Council of Presidents of the United Nations General Assembly, and also advisor to the United Nations Development Program, independent expert on decolonization, and political status advisor to various French, British, Dutch, territories in the Caribbean and Pacific.
Thank you. My name is Charles Salailima, and I am an attorney here in American Samoa. I was born here in American Samoa, but I was raised in what would become independent Samoa. And I also went to school in Hawaii, graduating from the University of Hawaii Law School back when it was sitting down in the quarry, and in the late 70s, and returned to American Samoa to do my practice. I've been practicing law since '79 in American Samoa. I started off as the Assistant Attorney General, dealing with mostly with prosecutions, criminal matters, then as the District Judge, which is a municipal judge, and then as an acting Associate Justice, which is the general jurisdiction. Then I left the judiciary and decided to go into private practice because I wanted to try to bring issues that are important, I think, to the courts. And it was important to have somebody, lawyer, to come in to bring those issues in front of the court. The most interesting part of my practice for the last 40 years has been this interplay between customary practices and US-based laws that we operate under, and trying to integrate the two into something that's comprehensible both to the judicial branch and also to people who have to deal with the judiciary and with the law and the governance on a day-to-day basis. You know, a lot of the frustrations that I know Samoans feel is that they can't understand what that situation is. And that's basically what I've been doing for the past 40 years, is to try to bring some understanding to trying to integrate those customary practices into a judicial framework that is able to, that is comprehensible to the society. Thank you for the time, and glad to see the ABA is getting its interest in this. I used to be the ABA delegate 5 years ago.
I guess that leaves it for me to go. Half a day in Derieux from the beautiful island of Saipan in the CNMI. It's my thing on? Yes. Okay. My name is William Fife, and I'm a professor at Northern Marianas College. As a retired lawyer, I am now inactive and only teach full-time. I'm in my 12th year of public service in the Pacific, beginning as a U.S. Peace Corps volunteer in the Kingdom of Tonga, then as a legal aid attorney with Micronesian Legal Services Corporation in the Marshall Islands and the CNMI, and now as an educator here in Saipan. I'm honored to join the panel today discussing the legal legacies of U.S. empire. The stain on our legal system has survived for far too long by living in the shadows of ignorance. So on behalf of my amazing students and I, thank you all for bringing cleansing light to today's topic. I also want to thank Right to Democracy and the Ford Foundation for the Summit on U.S. Colonialism recently in October. It really brought some much needed hope and energy to the territories. Thank you all for your work putting together that historic meeting. To conclude, I've recently published Potential Solutions to Our Predicament, which focus on leveraging Indigenous rights to support the strength of people who survived hundreds of years of genocidal colonialism. It's a pleasure to be with all these esteemed panelists, and I look forward to hearing from everyone's presentation. Thank you.
Terrific. We'll try to keep things moving quickly. Starting with Jacqueline, could you talk about how U.S. policies have affected Indigenous communities in the Marianas and what could be done?
Yes. You know, that is a loaded question, right? So we were trying to narrow this down because I could probably talk for at least a day on this topic. It's been 125 years. But, you know, I want to focus on something very basic. You know, I don't know if everyone is familiar with what we call the Compact Impact Free Association Agreement. It essentially allows the Pacific nations like the Republic of Palau, the Marshallese Islands, to travel into the U.S. Without any immigration status of any sort, and basically live and work in the United States as if they were a United States citizen. Well, the impact to places like Hawaii, the Northern Marianas, and Guam is simply that our little entities are absorbing this huge migration for a United States policy, because the policy is they've entered into this agreement. This is a 20-year-old agreement. And in this 20-year-old agreement, what the United States receives is they receive access to both land and water, basically a military purpose in the Pacific, so that they have this Pacific presence. So this federal policy allowing for their presence in Guam, allowing their presence primarily in Hawaii and in the NMI, is simply that our entities bear the brunt of the cost of this migration without any substantial contribution or benefit to our locations. So, I'll start with the grant from the United States. So for example, Guam typically gets what we call a $12 to $16 million grant reimbursement. The federal policy is that it's intended to reimburse Guam for the expenses of migration from the Pacific, right? And that sounds not so bad, right? $12 to $15 million. I don't know anyone on the panel who has $12 to $15 million to go spending today. But for those of us who don't, right? And we say, okay, that sounds like a good amount. You say, well, how much exactly does it cost the islands to absorb this migration? Guam annually spends about 150 million in the absorption of this federal policy. And so as a result, Guam's medical facilities are run down. Our educational system is run down. And we talk about federal policy as it relates to education. There is segregation occurring in our islands. We have the military school systems here. We have the Department of Defense educational system, and the Department of Educational System, its majority budget for their system is spent here in Guam. We have a massive DODEA system is what we call it. So while the children of military are attending an educational system that is on par with American value, we have a system in the local government that is being unduly burdened for the last, at least the last 20 years, to foot the bill for migration on this federal policy. And as a result, our healthcare system is crashing. Our educational system is crashing. In fact, I've got a 3-year-old. He has special needs, right? So he's in the public education system. And in the first week of school, they shut down. Why? Because the government hasn't maintained its facilities, and they determined that the facilities are not safe for students, right? And our schools were built back in the 70s. And as a result, right? So imagine your credit card, right? If you started putting $100 million, $125 million, even 140, if we want to be realistic here, $140 million every year, and all you paid was $12 million a year to that, right? It's never going to be able to be paying itself off. And so as a result, the shifting of burdens is on the local population. And so when we talk about all the issues surrounding our Indigenous population who are here, who live and work here, in the end, because of the growth of the military population, the growth of the educational system, what happens is the local population says, wait a minute, I can't live here. It's too expensive. And so we've had a huge migration of our Indigenous population abandoning its roots and culture in favor of an extra dollar. And why? Because the system has created an environment where we have had to choose. We need to choose between feeding our children, having some kind of work to pay for our $1,100 power bill a month. And so that's the thing, is it's created a system that makes it impossible for our Indigenous population to stay on our island and to work on our island. In fact, I think this particular year, we've had a massive migration out of Guam. The territories are very familiar. We have this thing we call brain drain, right? The fact that all the territories have it, right, is indicative of the huge problems that we're seeing in the territories as a result of the continuing lack of clarity on the relationship between the federal government and with the territories as itself. So the last one I wanted to just talk about briefly is kind of the plebiscite vote, right? A self-determination of some sort for the Indigenous people, right? The Indigenous people who were here on Guam, who survived the war, and who were granted rights as citizens under the Organic Act of Guam, which is a federal statute. Well, the problem is that even though Guam has made efforts to try to get to a plebiscite vote, to get some kind of vote on determination, every effort we have made in the court system has failed. First, we defined it as Chamorro, right? Those who were of Chamorro descent. And the court said, you can't do that. It's racist, right? I said, okay, so let's use our federal statute. We'll base it on a federal statute, right? That gave us citizenship. And we will say all native inhabitants who were present in 1951 before this cutoff date, and then it's okay because that's not race-based in any sense of the word. And essentially the court said, the Ninth Circuit said that it's a pretext for race because the only people who were there in the 1950s were the local people plus 300 foreigners. And so, therefore, when we look at the federal policies that are battling against one another, every time that we come against the constitutional right of full U.S. citizens, those who are protected by the Constitution, and those who live in the territories, every time the territorial citizen basically has no right. So I have no right to say that I should have some kind of self-determination. So we have not been able to get to a vote, despite the fact that it's been 75 years. So I'll stop there.
Thank you so much. Leah, could you speak to the economic challenges that Puerto Ricans have faced and perhaps how that relates to the broader challenges encountered by all those living in the territories?
Absolutely. And actually, Daniel, you started, or part of your remarks at the beginning, highlighted the poverty of the territories. And I think that when we're talking about economic justice, we have to start by recognizing that the 5 inhabited territories of the United States are poorer than all 50 states and the District of Columbia. American Samoa is the most poor territory of the United States. In 2022, the rate of poverty was 57.8%, followed by the Northern Mariana Islands with a 52.3%, by Puerto Rico 43.5%, Guam 22.9%, and U.S. Virgin Islands 22.4%. That's the population below the federal poverty line. Let's also remember that just because maybe somebody is a few $1,000s above the poverty line doesn't mean that they're buoyant. So we could also add, a lot more people to those terrible statistics. And these very high levels of poverty, that is a result, particularly in large part, at least, of the territorial framework that exists with the territories. And it's very important to know and to understand that, as I believe Adriel mentioned this in part of his remarks, is that the different laws and policies that apply in the territories are not even uniform. And we don't even understand why. I mean, it makes no sense in the situations. So I'm just going to mention a few, because there are many, but for time's sake, I'm going to only mention a few of the most burdensome laws that negatively affect Puerto Rico, but also the other territories, and that contribute to their levels of poverty. So many people know, but for those who are not very aware, for me, the most important one is the Merchant Marine Act of 1920 that regulates maritime commerce in the United States, and specifically Section 27, which is the Jones Act. And the Jones Act regulates coastside trade policies. And it's important to note that the Virgin Islands, American Samoa, and the Northern Mariana Islands are exempted from the Jones Act. So the Jones Act only applies to Puerto Rico and to Guam, which has one little exception, but still primarily it does apply to Guam. And it has very strict requirements where ships delivering goods must be made and registered in the United States. They must carry the US flag. They must be owned and controlled by a US company or citizen. And the crew must be primarily US citizens. And then all of those requirements make US shipping much more expensive than foreign shipping. And the Jones Act significantly raises the cost of all of the goods that go to Puerto Rico and to Guam. Puerto Rico imports approximately 85% of all of its goods, and I believe Guam is even higher. I believe it's around 90%, if not higher than that. And so when we think about just getting goods into these two territories at such high prices, territories that already have a very high level of poverty, we can imagine what the situation is. And what can be done is we need to repeal the Jones Act. We need to pressure Congress to repeal the Jones Act, or at a minimum, to make waivers of the Jones Act automatic immediately after natural disasters, so that necessary food and supplies and medicine, et cetera, can enter into Puerto Rico and to Guam in times of need, which all of us remember many situations where that has been delayed and very unjustly. So another area that I want to focus on very briefly is nutritional assistance. It's really, really important. We all have heard about SNAP, particularly because we're hearing a lot about the Farm Bill. So the Supplemental Nutritional Assistance Program, or SNAP, is the nation's most important and most generous anti-hunger program. And it operates in the 50 states, the District of Columbia, Guam, and the Virgin Islands. But it does not operate in Puerto Rico, American Samoa, or the Northern Mariana Islands. And those are precisely the 3 US territories or colonies that have the highest poverty rates in the United States. And these territories instead received capped block grants, and they have different names that I'm not going to in different acronyms, but each of them have, except American Samoa, each of them have their own programs that significantly pay at much lower rates and put less money in the pockets of needy individuals. And not only that, but contrary to SNAP, which expands automatically in periods of great need, these programs require congressional action to allot additional funding in the case of natural disasters or emergencies. And so that obviously puts a great limitation on the benefits that they are receiving. I want to mention that Congress, in other words, in order to be able to solve this problem, Congress needs to amend the law to include Puerto Rico, American Samoa, and the Northern Mariana Islands in SNAP. And I believe I misspoke previously about American Samoa. American Samoa is excluded. And in March of this year, there was 16 senators that introduced the Puerto Rico Nutrition Assistance Fairness Act. That's Senate Bill 949, to amend the Food and Nutrition Act of 2008 and to transition Puerto Rico back into the SNAP program. Because another thing that I want to mention is that Puerto Rico was in the SNAP program and was eliminated under the Reagan administration, and that's a whole other discussion. And the bill is currently in the Agriculture, Nutrition, and Forestry Committee. Now, finally, I want to talk briefly about the supplemental security income. And many of us are very familiar because unfortunately, we lived through this recently in 2022 in the devastating decision of the Supreme Court in United States v. Vaello Madero. SSI, or Supplemental Security Income, is available to residents of the 50 states, DC, and the Northern Mariana Islands, and it offers cash assistance to low-income individuals who are either elderly, blind, or disabled. It's not available to residents of Puerto Rico, Guam, the US Virgin Islands, and American Samoa. And residents of Puerto Rico receive benefits through the Aged, Blind, and Disabled program, and the other territories have their own programs as well. And unlike SSI, which operates as a flat rate entitlement, the number of beneficiaries in all of the other programs is limited because it has capped funding. So it's limited to the amount of funding that is available. And again, one of the contradictions and infuriating contradictions that occurs is that, for example, for SSI purposes, the territories are not considered part of the United States, except for the Northern Mariana Islands. But under another section of the Social Security Act, they are considered part of the United United States, and their benefits fall under what are called adult assistance programs. And again, except for American Samoa, here, American Samoa does not qualify either for SSI or for any of the adult assistance programs. Also, SSI is 100% federally funded, while the adult assistance programs require a contribution from each of the localities. And again, we're talking about territories that are very impoverished. So this has been challenged in the courts in several cases that have reached the Supreme Court in the recent past, and particularly on behalf of Puerto Rican residents that have been denied equal benefits, the latest being the United States v. Valle Madero, but there have been others. And unfortunately, the Supreme Court has consistently ruled against the territories, and we won't get into that because there's no time right now, but that would be great to have another discussion about. And finally, in terms of what can be done about this, Congress must amend Title 16 of the Social Security Act to require that SSI benefits be provided to all eligible United States residents, including Puerto Rico and all the territories. And if you remember, at the start of the current administration, President Biden attempted to do this with the Build Back Better Act, but the provision providing for SSI benefits was removed from that act. And then the act was transformed into the Inflation Reduction Act that passed, but that has no provision for SSI. So in other words, it's really, really important to continue with legislative advocacy as well as litigation to pressure Congress and the courts to treat the territories with respect to the discriminatory laws and federal policies.
Thank you so much. Carlisle, you took part in self-government assessments in Guam and the U.S. Virgin Islands. I know one question that comes up a lot is, short of independence or statehood, what would useful models be? So I'm wondering if you could speak to effective models of representation and autonomy that seem plausible.
Yes, well, the assessments that were done were for Guam and the British Virgin Islands. We have not done an assessment for the U.S. Virgin Islands, but the Guam assessment, as other ones that we do for other non-self-governing territories, is seen from the perspective of international decolonization process under Article 73 of the United Nations Charter. There's a list of 17 territories presently. American Samoa, Guam, and the U.S. Virgin Islands are on that list. As a result, there are a number of international law provisions applied to the decolonization of our territories. Now, overall, the solution to the political inequality for U.S. territories, I would argue, lies in a genuine self-determination process leading to decolonization, just as in the case of other territories administered by other countries. I think we're finding that in the case of Guam, which has a self-determination process, a decolonization process underway through its commission. Puerto Rico is addressing it through the courts as well. They're addressing it through legislation. And recently, Senate bill was approved, and also the House bill has been reintroduced. So we see the point, and in fact, those two territories, particularly Guam and Puerto Rico, have removed the status quo from the equation. They're no longer considering the status quo as a valid option. In fact, the option is one of political inequality, and therefore there's decisions have been taken to only address the three options recognized both by the White House reports on Puerto Rico as well as the Resolution 1541 of the United Nations General Assembly, those options being independence, free association, and integration. And we have a number of wonderful models of all three of those throughout the various regions, particularly Caribbean and Pacific. We look at, if we want to look at the conclusions of the Guam assessment, I think they might be instructive for other territories as well. First of all, the territorial model in Guam exists under a unilateral authority which prevails over the political status relationship in virtually all substantive areas of governance. This is one of the findings. So the decisions of the elected government are, and this is the case for all territories essentially, are subject to unilateral override through the application of U.S. laws. And this is considered inconsistent with democratic governance. The second, one of the findings certainly is that looked at the Guam Commonwealth Act and how that was rejected in the 1990s when the issue determined that the kind of autonomy that was required and requested in the act was not possible under the territorial status. Another finding looked at the issue of the entire arrangement of territorial status being anachronistic and could not necessarily be reformed, but rather it only can be replaced. If Guam and other dependencies remain in the status quo, full self-government cannot be achieved, but only further deferred. A territorial constitution, for example, Guam tried this year, many years ago. U.S. Virgin Islands tried this 5 times, and I believe we're looking at a 6th. A territorial constitution would not solve the dependency dilemma of territorial status because it would really render a result of lesser inequality rather than a full equality, full political equality as is required. The fundamental democratic deficit inherent in the dependency governance model in Guam did not meet and does not meet the international minimum standards for the full measure of self-government. So the current status can serve the purpose of further preparing the territory in a transitional context for full self-government. And that would, of course, be with respect to the 3 options that are recognized as I referred to earlier. Now the territories are governed under the UN Charter with respect to the obligations of the United States as the administering power of these territories. And since the signing of the Charter in 1945, and 1 year later, the U.S. inscribed all of the territories, including Puerto Rico, on the UN list as a result, recognizing that, in fact, the territorial status is one of a preparatory status. It's not the embodiment of self-government, but rather the preparatory to self-government. The international self-determination process really is often dismissed, misunderstood, or even misrepresented and omitted from the territorial political discourse. U.S. statements to the UN, for example, in the 4th committee of the General Assembly that deals with decolonization, gives the impression that there's a permanency to the territorial status. But on the other hand, in the Congress, there's a different perspective that is articulated. So this is an inconsistency with the UN Charter obligations to advance the territories to the full measure of self-government, and that is Article 73B. Thus, the conversation in the territories often centers around dependency reform and modernization and legitimization. And I think we have a number of dependency modernization efforts, and our leaders over the years and over the decades, dating back over a half century, are to be commended for their attempts to adopt territorial constitutions, and increasing rights in the U.S. political system, such as presidential vote, delegate representation in the Senate, vote for the in the House of Representatives and full vote in House of Representatives, among other initiatives. But these have been very difficult to achieve. The outcome of these initiatives serves to highlight the political inequality of the territories. And of course, most recently, with reference to the rejection of the Insular Cases is another initiative aimed in that direction. Many of these initiatives may have some unintended consequences, particularly in terms of the rejection of the Insular Cases, because the question would be whether this would nullify the unincorporated territorial status and transform us by default to incorporated territories, however, with the continued application of the territorial clause. Now, we know that incorporated territory is a precursor to U.S. statehood, but the people haven't necessarily voted for U.S. statehood. So this is a concern that some are articulating, the potential for other consequences. I think one of our earlier speaker made reference to the Jones Act exemption that we have, thankfully. But these are vulnerable. These are things that of this nature can be vulnerable to reassessment if we move from the status of unincorporated to incorporated. So these are issues that should be looked at carefully in the context of this legislation that's being looked at. In effect, overall, it is concluded that the unincorporated territorial status has long reached its zenith within the U.S. political system and cannot be advanced sufficiently to achieve full self-government as required under international law. Accordingly, international decolonization doctrine indicates that full political equality is best achieved through a process of self-determination, which leading to decolonization and a selection of one of the three options of independence, free association, or integration. Overall, there remains a very firm U.S. obligation under international law, under the Charter of the United Nations, to advance the territories under its administration to full self-government, not to legitimize political inequality under a territorial status which was never meant to be permanent, but rather as transitional and preparatory to full self-government. And this obligation of the United States remains unfulfilled. And I think I'll stop there.
Thank you so much. William, we have one more question. I'm wondering if you could speak to the UN Declaration of the Rights of Indigenous Peoples and particularly its effect on or how it might be used for self-determination or the advancement of cultural rights.
Great, thank you so much. Several of the panelists here today attended the 2021 congressional hearing regarding a resolution to denounce the insular cases. My collaborator, NMC's Dr. Behlul Solomon, and I recently published a USC Law Journal article titled Indigenous Rights, A Pathway to End American Second-Class Citizenship. We framed our article around that congressional hearing, and now I'll include you all in that dialogue. So just some questions to consider, some potential solutions, and some parting critical thoughts. Question number one. Does the lack of territorial consensus regarding denouncing the insular cases give life to systemic racism and second-class citizenship in the US? Amicus briefs filed on behalf of Indigenous peoples in the CNMI and American Samoa paradoxically argue to keep systemic racism alive because they believe the insular cases creates a legal space for Indigenous land rights to exist. Bipartisan SCOTUS justices share interest in overturning the bigoted insular cases. It's also important to remember that there is debate over whether or not the insular cases are even necessary for Indigenous land rights to exist in the CNMI and American Samoa. Question number two. Even if it is true that it is necessary to take a, quote, long live the insular cases position to protect cultural survival, what happens to Indigenous land rights in US territories if SCOTUS overturns the insular cases? For example, would the CNMI Indigenous land rights law known as Article 12 become unconstitutional? Would cultural land rights norms in American Samoa become unconstitutional? As CNMI Delegate Kalili astutely mentioned during that same congressional hearing, legislative solutions are necessary for Congress to address a potential sinking anchor instead of a life preserver for already threatened Indigenous cultures. More than 2 years has passed since that congressional hearing on denouncing the insular cases. Where are the solutions? All right, so here's a couple solutions. Number one, let's legislate Indigenous rights. So implementation of the United Nations Declaration on the Rights of Indigenous Peoples, also known as UNDRIP, at local and federal levels provides legal Indigenous land rights protections that could unite the CNMI and American Samoa to denounce the insular cases, thereby enhancing territorial solidarity as a consensus signal for Congress and SCOTUS to take action. British Columbia and Canada are recent case studies of local and federal UNDRIP-based legislation. If the US did the same, the CNMI and American Samoa could be more likely to denounce the insular cases as unnecessary for the sustainability of Indigenous land rights in US territories. Solution number two, truth and reconciliation. Examples are South Africa with Nelson Mandela and Archbishop Desmond Tutu in the aftermath of racist apartheid, and more recently with Canada investigating and highlighting Indian boarding school atrocities. This process is essential in public education and healing the legacies of genocidal colonialism. Many possible outcomes. Many possible outcomes could range from including a territorial curriculum, educating American students about the racist history and reality of second-class citizenship, or possibly even reparations, as happened in Canada to address the mass graves and sexual abuse of Indigenous children at Christian-based schools. So some parting critical thoughts. The insular cases, which were only meant to create a temporary unincorporated status, are now well over 100 years old. Be that as it may, the insular cases are but a symptom of US colonialism, not the cause. The root from which the insular cases grew is 1823's Johnson v. McIntosh and the legal incorporation of the international law called the Doctrine of Discovery, which is now in its 200th year anniversary of active American case law. As admirable as it is to tackle the inequities in the territories, if we are to truly decolonize the US empire, we will have to go beyond just the insular cases. The arguably unconstitutional insular cases ruling in Downs v. Bidwell in 1901, as quote, differing from us in religion as one of the elements in the equation establishing second-class citizenship, shows dependence upon multiple Johnson v. McIntosh citations, which of course relies upon the doctrine of discovery that A, comes from a religious institution, the Vatican, and B, legalized land theft due to the fact that Indigenous peoples were not Christian at the time of discovery. This religious element to the legal equation could potentially add a First Amendment violation along with 15th Amendment race-based arguments against the insular cases. To destroy American systemic racism and the legacies of colonialism, root and stem, would require the overturning of what my collaborator and I call the discovery cases. Cases which rely upon the doctrine of discovery and include Johnson v. McIntosh and the insular cases. There are no insular cases without Johnson v. McIntosh, and no Johnson v. McIntosh without the legal foundation for colonialism, the Vatican's doctrine of discovery. To conclude, if territorial consensus denouncing the insular cases is necessary for SCOTUS to overturn them, or even if the insular cases are necessary for Indigenous land rights to exist, implementation of UN-based legislation could be a solution in both scenarios for a reality that includes both Indigenous land rights and the end of the insular cases. Local and federal Indigenous rights legislation could simultaneously support dismantling American systemic racism and second-class citizenship, allowing for the self-determination space to grow for all territories in the democratic manner of their choosing. We cannot settle for the status quo. Our resilient youth, who also suffer from suicide rate disparities and dire mental health issues rooted in intergenerational trauma, deserve to know a world is possible where their cultural survival is not dependent upon our American government referring to them as, quote, savages and uncivilized alien races. Thank you very much.
What a place to end those remarks. I realized that I switched the order a little bit, and I apologize for that. Before we go to Q&A, and I hope we'll have a little time for it, Charles, I would like to ask you to reflect on the implications of the Fitisimanu case for the both for American Samoans and more broadly for residents of the territories.
Yes. Well, thank you for the time to talk about this. I'll talk briefly about the Fitisimanu case, because it's part of the Tuaua case and the Fitisimanu case in dealing with citizenship. The primary reason why citizenship became important is because it was the most direct path to get a review of the insular cases, because there was a clear issue and there was a clear solution, and it didn't involve all these other things of congressional actions with money or the Jones Act or other things like that. So it gave a direct route and a fairly direct route to see if the Supreme Court will take it up and repeal the insular cases. Obviously, they didn't because they did not grant cert to do the review. So the insular cases still stand until there is a compelling case, at least in the Supreme Court's mind, to come back up. So I guess Brown versus Board of Education was the last of a long series of efforts to try to overrule Plessy v. Ferguson. Well, that's basically where we're at now with respect to the Fiti-Simanu case. I'd like to address the issue with respect to the various ways in which these colonies came under U.S. jurisdiction. A lot of it, obviously, the Spanish-American War was a war of conquest and a forcing of allowing the Americans to take over a bunch of the Spanish colonies. American Samoa was a lot different. What had happened was in 1889, there were a standoff between the British, the Germans, and the Americans in Apia Harbor, in which they were going to try to say who is going to control this archipelago. A storm came up, wrecked the two American ships, the American ship and the German ship, shipwrecked those sailors and killed a number of them, but the British got out, and they were able to then, this is gunboat diplomacy at its best, basically stand off and basically force an issue to what they call the Treaty of Berlin in 1889, where they basically tried to model the archipelago under the kingdom status, just like the British had done with Hawaii. And in that particular, and what happened was they said, well, who's going to be king? Well, they made this king one of them, who they thought would be the high chief, the highest chief of the land, Malietoa. The problem is that's not how Samoans see their sovereign. They say, who died and made you king? Because there were about 4 other high chiefs who said, hey, we should be king. And one of them went into rebellion. And after about 10 years, the Americans, the Germans, and the British saw that, hey, this is not workable. So they decided, okay, now we're going to try to divide up we will try to divide this sovereignty up. They divided the sovereignty. Americans just wanted that harbor in Pago Pago, and the Germans wanted their plantations on the bigger islands, and the British basically got some concessions elsewhere. I think somewhere in the Mideast, they got some concessions out of this. So they withdrew, and they told the Americans, you go deal with those chiefs over on this side, and Germany, you go deal with the chiefs on that side. And so when Captain Tilley came waltzing into Pango Harbor, the Americans already had a very good connection to the harbor area because of some San Francisco tradespeople. So they had the chief there who was very anxious, had been for decades trying to get American Samoa under America. So he was welcomed, and they helped him go out and identify the various chiefs that that wanted to be part to sign off on the deeds of cession. What is important, however, was that the traditional sovereigns, these high chiefs called Tamainga, they actually withdrew from these islands, conceding that America now is going to be the top sovereign here. Similarly, 4 years later, the Tui Manua, who was the high chief of one of the other islands, he gave up, he signed his deed of cession for his islands and extinguished his title. So now we have at the top and so in terms of how you became part of the United States, right? It was very much different from what happened in Hawaii and what happened in Puerto Rico and under the Spanish-American War. It was actually a very voluntary act. The problem was that those guys that signed the deeds of cession thought they were U.S. citizens from the beginning. They were very surprised in 1929 to have this federal commission show up and tell them, hey, you're not really citizens. And that commission, they was actually told by chiefs who were right close in time to that signing, saying, I thought we were. So they went back to Congress. It passed the Senate to make American Samoans citizens. But at the House of Representatives, you read the transcripts of what happened there. It was just racially motivated. And in essence, basically, they said, you aren't going to be U.S. citizens, or that we were going to, and that's how we started this whole national status. In the 1960s, the Western Samoa, the German side, became independent. It had gone to New Zealand, and then now it became independent. and it had its own constitution. The American government at that time, and under the Department of Interior, did not want to have that, did not want to look like they were still dealing with a colony and we're moving ourselves forward. So the Department of Interior made a constitution for American Samoa. And in that particular one said, okay, we are going to create this constitution for you, American Samoa. Congress was the Secretary of Interior was exercising his plenary authority given to him by Congress to the president and delegated down to the Secretary of Interior to have the control over the islands. Since that time, there have been some changes that have been made. One of the things that was done was we had this case called King v. Morton, in which they went up and they said, oh, fundamental rights to jury trial apply down here in American Samoa, constitutional fundamental rights to a jury trial. I was a young lawyer in the prosecution office at that time, and I was charged to try to figure out how to integrate jury trials into the system. And we had said, oh, it applies to everybody. Okay, so jury trials were for all Samoans. What really surprised me was up in the district court in DC when we were doing an appeal, or the circuit court in appeal, was that one of the judges apparently knew about this case or hadn't even been on it. And he said, oh, that was only supposed to apply to Jake King. He has a right to a jury trial because he's a US citizen. And it sort of blew my mind that somehow they were thinking that this right to jury trial was not, he got his jury trial right because he was a US citizen. Because from the time that we were trying to implement jury trials down there as a fundamental right, we had thought, okay, that applies to all of us down here. It was just surprising to see that kind of thinking was somehow in the judge's mind. So again, the issue that really needs to be focused on is what is this plenary authority, and how far is the Constitution going to be, imposes itself on the exercise of that plenary authority that's granted to Congress, and Congress gives it to the federal executive agencies to implement down here. Does it apply? And this is what the citizenship case was really about, was everybody seemed to concede that, yeah, citizenship is a fundamental right? But then the question is, look, if it's fundamental, you've already said it's fundamentally applied to, fundamental rights apply down here. Why aren't we citizens by the fact of our birth in US sovereign territory? So I think in the end, what it really boils down to is America has to get its act together. The US government has to get it, and even judiciary have to get their act together to say, what do we mean by this? And the Samoans themselves have to address this issue directly themselves, because they say, oh, we're worried about our custom and culture. Well, custom changes from generation to generation to generation. Custom is not static. If it's static, it's dead. Okay, and the key of the key to keeping custom and culture is to make themselves relevant to the situation each generation finds themselves in. And the Samoan culture is very, very flexible. They adopted Christianity. They adopted, U.S. constitutional government. The heads of the old traditional system left, and we have this culture that keeps changing. But then somebody says, somehow we're trying to protect our custom and culture. No, that's up to Samoans to do that by the way they act. I think America, however, has to get its act together and say, no, this is how the relationship is. And the idea that somehow the Matai, or the chief system that we have, is not democratic is wrong. Is wrong. It's an indigenous democracy, starting first with the underlying family rights. It is not a royalty kind of thing that people seem to adjudge to the chief system. Polynesian system was never, in a sense, the kind of royalty that you would get from Britain, because that's a British idea. This idea of the descent to your son and only to your child, that was never a part of the traditional Polynesian system. Polynesian system, the leader basically was a consensus group saying, yes, you'll be our leader, because so a guy during times of war, the guy that's the best warrior, hey, he's the big shot. Times of peace, the guy that can create the nicest monuments and, build things and organize people to do things, he becomes the TUI. So, and in that sense, I think that's what I've been doing for the last 40 years, is try to integrate those two melded into one, so that it becomes comprehensible both to American legal systems and to the Samoan system. So again, it takes a little time to do that, but that is the key to getting this cultural legal issue resolved. Thank you.
Thank you so much. We are plumb out of time, and I see there's so many questions, so I'm going to bring this to an abrupt but grateful end. I want to thank the ABA's Civil Rights and Social Justice section. I want to thank our partnering organizations, and I want to thank these amazing speakers for a wonderful conversation. I hope that we can continue it in all kinds of ways. Territories matter. Thank you so much.
Thank you.